Yes, Your Honor.
All right. I think Takaya McKay was a former client of yours, so if I remember correctly. There you go. Right. All right, Ms. Spiegel, if you want to go ahead and start your video and your audio. Thank you. All right, so we are back on the record in the matter of the people of the state of Michigan versus Briana Spiegel. Ms. Underwood represents Ms. Spiegel. Ms. Underwood, have you had an opportunity to speak with Ms. Spiegel?
I have, Your Honor.
All right, and Ms. Spiegel, you would ask for court-appointed counsel at the last hearing. We did appoint Ms. Underwood. So have you had ample time to read and review the probation violation recommendation with her? Okay. We're not that room, Briana, has horrible audio. So if you can scoot up and speak a little bit louder for me. Have you had a chance to read and review it with her?
Yes.
All right. Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yeah.
All right, good. Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the probation violation report?
We do not, Your Honor.
All right. Now, Ms. Underwood, is there anything you'd like to say on behalf of Ms. Spiegel before the court passes sentence?
Your Honor, I think recovery court is familiar with the fact that people, no matter how well they're doing, occasionally have relapses. And I think that's what Ms. Spiegel found herself doing, Your Honor, and she apologizes, and she knows that recovery court is the proper place to address that. And she welcomes the opportunity to do that. And I think she welcomes the opportunity to sit down with Ms. Tetsky and decide what kind of future treatment is appropriate. And the sooner she gets back into recovery court, the better, Your Honor.
Excellent. Thank you. All right, Ms. Spiegel, anything you want to say on your own behalf?
I just want to say thanks for giving me another chance.
Okay. Ms. Teskey, anything you want to add?
No, Your Honor.
All right. So it is a sentence of the court that on docket number 22-20816FH, we will revoke her probation without improvement. On docket number 24-21737FH and 24-21738FH, I'm going to continue you on probation and in the recovery court program. I am going to order you to serve 6 months in jail with early release to residential treatment. So Ms. Teskey will work on setting that up, or someone else on the team will. And then you are not to have any contact with Joseph Strong, okay? Verbalize that. Okay. Yes. And okay, good. Ms. Spiegel, you know, you've done amazingly well and things do happen, but I believe that you can overcome this, and I hope to see you soon in recovery court, okay? Mm-hmm. All right, now you do have the right to appeal this sentence, and they're going to give you 3 copies of your notice of right to appellate review. They'll have your initial and date, 1 copy on each file for our records. The other copies are for you. And if you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Okay.
Thank you. See you
Thank
soon.
you. Yep. Hopefully see you soon.
Yeah, you will. That's the shortest wait you've ever had.
Yeah, I know. I was like,
Yep.
Her eyes must still be sleeping. Thank you.
You're welcome. All right, I have somebody at the jail. What is your name, please?
Melanie Layman.
All right, let me get in there, find your file. All right, in the matter of Kathy Ann Wilzer versus Melanie Layman, file number 25-52956PH. This is a Judge Olsaver file that I'm handling. He is not in today. So we have a personal protection order that was filed on September 5 of 2025. And I show that it was served on September 7th of 2025. And Ms. Layman did sign an acknowledged service, and it was by a deputy rights scam or something like that. So Ms. Layman, we are here today on alleged violation of the PPO. Let me see what the show says. Hold on one second. So Ms. Underwood, as I just wanted to give you a heads up, but when I reviewed the information on the jail sheet, it says obstructing court order. I'm assuming that's just the PPO, and I don't show that there's anything else listed there. So Ms. Layman, it is alleged that you have violated the personal protection order, and that on or about September 11 at 1300 hours, you flipped off the protected party, flipped off the neighbor protected party door. You then went up to the door and put your head up against the door. Throughout the day, you had been seen walking in front of protected party's front window. Protected party felt harassed and threatened. So it looks like you guys maybe live in a duplex next to each other. Oh, hold on, Ms. Lehman. So those are the allegations against you. Violation of a PPO can carry up to 93 days in jail and up to a $2,000 fine. So Ms. Lehman, you do have a right to have an attorney represent you here today. If you can't afford to hire one, we will appoint you one at public expense. Ms. Underwood handles these matters for my court. Would you like a court-appointed attorney?
Yes, please.
Okay, so I am going to open up a breakout room.
Am I able to speak at all?
You will, now that you've asked for an attorney, you'll get to talk to her, and then you guys will come back in and we'll see what we're gonna do.
Okay, thank you.
You're welcome. All right, Ms. Underwood, join the breakout room. What did, I don't have Mr. Barnett. You're supposed to come in person, right?
Yeah, you know. He recorded Tuesday, but I'm hearing he's still living with her.
All right, well, he's not here. He's got to show up. You like when they show up.
You know, I don't know why. I don't know what he's thinking. Like he just said he wants to just max out.
Yeah, let's see what he says if he shows up.
Actually, the best behaved thing that I've ever seen on Tuesday.
Yeah.
He's pretty mellow, but. Yeah, just in person.
Isn't logged in either. Maybe Rhonda can,
Okay, calm down, officer, I'm all right.
It's a matter of opinion.
all right, Ms. Underwood, let me close that breakout room. All right, so we're back on the record. So Ms. Underwood, have you had a chance to speak with
Yes,
Ms.
Your Honor.
Layman? All right, and how would you like to proceed today?
Your Honor, Ms. Layman has the documents filled out at home to object to the PPO that she is going to file. This is not a aggravated violation in any way, the allegation. Ms. Layman has knee surgery scheduled for Tuesday, Your Honor, that she does not need to be in jail with her knee. I would suggest that Ms. Layman has been cautioned to avoid even the appearance of contact, Your Honor. They do live in close proximity, but it was supposed to be possible for them to do that. She now understands that she needs to not even wink in their direction. I would ask that a not guilty plea be entered and a date be scheduled for Judge Olsaber, and Ms. Layman be released on PR, Your Honor, with the caution that nothing else.
Is she gonna plead then?
No, I'm just going to plead not guilty, Your Honor.
Okay. All right, I will, Miss Adams or Miss McGrain, when can I set this over next week? In front of Judge Olsaber, I guess she's gonna be in the hospital or something. Is it outpatient, Miss Layman?
It's outpatient, but my doctor doesn't want me leaving the house for at least 3 to 4 weeks. So if we could do Zoom, I mean, that's why I petitioned on the paperwork for that.
Okay, that's enough, Miss Layman. Hold on, I don't want you to say anything you shouldn't. So, one, Miss Layman, you're an intelligent woman. You absolutely knew you shouldn't have done this, so I don't think anybody need to caution you. This is not a de minimis violation of the PPO when you go out of your way to make sure that they see that if in fact you did that. So, I am going to set this out.
Judge Becky's on the phone with Ms. Clark.
So next week won't work. It would have to be probably 30 days out.
Judge, is this going to be just like a pretrial or a hearing?
Yeah, in front of Judge Olsaber.
Wednesday, October 8th at 8:15.
All right, so Ms. Layman, I'm gonna enter a not guilty plea. I'm gonna set it over for a pretrial on October 8th at 8:15 in the morning. That should give you time to recuperate. Ms. Layman, understand if there is one more allegation of a violation, you will sit in jail. Do you understand? Judge Olsaver, you know, does not like people messing with his PPOs. So I will release you on a PR bond. I don't want you even, is it the same duplex or next door?
I can't even sit outside next to her. I think, we have chairs both outside.
I know what it
alternate
is,
serves
yep.
that said-
So I don't want you looking at her. I don't want you walking on her side of the property. I don't want you to do anything. So we'll see you
As
back
long
on
as I stay
October
on my
8th.
side. As long as I
Yeah.
stay on my side.
Yeah.
I mean, that's
But
what, I mean.
that also means you don't flip her off from your side or yell at her or say anything. So October 8th at 8:15, I'll release you on a PR bond. If you violate again, though, there won't be a PR bond. So we'll see you back in front of Judge Olsaver on that day. Thank you.
Thank you.
So Ms. Underwood, Mr. Barnett did report to probation on Tuesday, but he's not here. Do you want to try to reach out to him?
I talked to him. Okay.
What's your name? Not with this judge, you know. I don't know, I haven't, of course, you know, Thursday and Angelo right now. 8:30.
All right, Ms. McKay, can you hear me?
Yeah, good morning.
Good morning. This is in the matter of the people of the state of Michigan versus Takaya McKay, file numbers 22-21047FH and 23-21323FH. So Ms. McKay, we're here on each file on two things. One is, let me find it here. Let me get back there. So there's going to appear. Hold on. Argentine. And okay, so Ms. McKay, we're here on two things. One is a violation of probation. On November 6th of 2023, a violation of probation was filed with the court, and it was a request and summons. The allegation is that you failed to report to probation for September and October, and you failed to pay fines and costs. At that time, it was a technical violation. Quite a bit of time has now passed since November, so it is now a non-technical probation. You were ordered to appear in the court on December 6th of 2023, and you failed to appear. And then there is the contempt of court. Let me see here. There's a contempt of court for December 6th. And then there is a contempt of court that you failed to appear for that contempt of court hearing. So the contempt of court can carry a maximum penalty of up to 93 days in jail. The motion affidavit and bench warrant on the violation of probation on file number 22-21047FH can carry up to a year in jail for the domestic violence second, and on file number 23-21323FH, that carries a maximum penalty of, did you plead on that file? Hold on. Only press. Get back there. I'm assuming it's the same thing, but Maybe I don't have it in the file, so hold on. Right, Mr. Adams, I don't show a violation of probation in the file on 23-21323. I have contempt of court, motion affidavit and bench warrant dated March 21. And then I have February 25 pretrial release order, violation of probation. Let me see, lien removal, maybe I do. Lien removal, bond conditions. Okay, yep, I found it. That was also filed the same date, so it's the same allegation and you're on probation on that file as well for domestic violence second. So if you were to plead guilty or be found guilty on either of these, you're facing up to a year in jail. Do you understand that, ma'am?
Yes.
Okay, now you do have a right to have an attorney represent you at this and all subsequent hearings. If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
Yes.
All right, so Ms. Underwood's here and we will appoint her to represent you. She's trying to reach a different client right now. So as soon as she comes back, we will put you in a breakout room with her to have a discussion. Miss Underwood, whenever you're ready, we have Miss McKay. No, she's in her turn. I'm trying to read.
Your Honor,
Yes,
Mr. Barnett is on his way. He had a different time. So he's on his way, Your Honor.
at defendant time. Yeah, yeah. All right. So Miss McKay has requested court-appointed counsel. So I'm going to open a breakout room for you to have a chat with her. Go ahead. Can I ask what your name is?
Anthony Sanchez.
Say it a little louder.
Anthony Sanchez, Your Honor.
All right, you're set for 9:30, so you got a while, you know that, right? Okay. All right, Ms. Underwood, I will close the breakout room. And Ms. Underwood, you understand because of the length of time that has passed, this is no longer a technical, correct?
I do, Your Honor, but,
No, let's
Yeah.
wait till she gets back. I just wanted to make sure. All right, we are back on the record with Ms. McKay. So, Ms. Underwood, how would you like to proceed?
Your Honor, I believe Ms. McKay is going to enter a plea today. There are circumstances that I think warrant consideration by the court, but I'll address those.
So, Ms. McKay, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so that room, the audio is not the best, so I'm going to need you to speak loudly for me, okay?
Okay. Can you hear me
Okay.
now?
Yes, excellent, thank you. All right, you can put your hand down. So, Ms. McKay, do you understand the allegations against you in terms of your violation of probation on these files?
Yes.
And you would ask for court-appointed counsel. We appointed Ms. Underwood to represent you. Have you had time to speak with Ms. Underwood?
Yes.
Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes.
All right, now, do you understand you have a right to contest these violation of probation charges and to have a trial on them? Do you understand that?
Yes.
Do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes.
Miss Adams, this is a misdemeanor file and the PO is Erica Williams. Would it be possible to see if they have a recommendation?
That's part of the problem, Your Honor. Ms. Williams, when Ms. McKay went back to report to her, no longer
Hold
worked.
on, no, hold on. Just let me get through what I need to get through and we'll talk about the problem later. But we sentence these the day of, so either I get a recommendation for her or I craft a resolution based on what you tell me. But let's wait till that point. All right, Ms. Underwood?
Thank
All
you.
right. So do you understand throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at the trial. Do you understand all of that?
Yes.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes.
All right, so Ms. McKay, on both of these files, how do you plead to the charge that you violated the terms of your probation by failing to report to the probation department in September and October of 2023 or any time thereafter, and that you failed to pay fines and costs? Guilty or not guilty?
Guilty.
Right, and how do you plead on the contempt of court that you failed to appear for a contempt of court violation of probation hearing on, hold on, I have March 19 of 2025. Guilty or not guilty?
Guilty.
Okay, do you understand by pleading guilty, you'll be giving up your right to a trial, as I've already explained to you?
Yes, I do.
Has anything been promised to you to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes,
Is it your own choice to plead guilty?
yes,
All right, so Ms. McKay, on both of these files, you were placed on probation for domestic violence second degree, which carries a maximum penalty of up to 1 year in jail. One of the terms of your probation is that you were to report as required. Is that correct?
yes.
And was that once a month or twice a month?
It was once a month.
Okay, and did you report in September and October?
No, I did not.
Okay, and can you tell me why?
I was in Detroit, Michigan. I wasn't down here anymore, and I explained that to her, and I talked to her, my probation officer.
Okay,
I was
So
homeless out
you-
here, so I didn't know where to go.
okay, so you were homeless and you were unable to get here and you had no vehicle, correct?
Yes, Your Honor.
Okay, and I'm gonna assume you failed to pay fines and costs because at that time you were homeless and had no ability to do so.
Yes, ma'am.
Okay, all right. Now, there was a contempt of court hearing noticed on March 19 of 2025. The only address we had was the Adrian address that you previously had, but at that time you were homeless, you didn't receive that notice, correct?
Yes. And then
And
when I
then-
came to court,
Go ahead.
they told me that my probation officer wasn't like, they told me to call down there. And they said she no longer worked there no more. Like she moved up to felony probation. And she was
Okay.
no longer there anymore.
Okay, did they give you someone else to report to?
No, they just told me to come up here and pay my fines off. They told me to go to the courthouse.
Okay,
Judge,
all right. All right,
Judge, it is, Mr.
Because I
McCarron
was-
is her officer. I'm unable to reach him at this time.
okay. All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. She has full knowledge of her rights. She does have competent counsel. So, Ms. Underwood, now you may proceed. Is there anything you'd like to say on behalf of Ms. McKay before the court passes sentence?
Thank you, Your Honor. Yes, Ms. McKay is now down here, Your Honor, and she has a job at Frickers. She's working regular hours, and they picked her up leaving her job last night. She very much wants to keep her job, and I think it's an advantage that she do so, Your Honor, to get those fines and costs paid. I would ask if the court would consider releasing Ms. McKay, sentencing Ms. McKay to time served, or perhaps delaying sentence, allowing her to work and pay those fines and costs, Your Honor. She had completed substantial amounts of her probation. I believe the fines and costs were the only thing outstanding.
Yes, that's correct.
What do you mean she completed substantial amounts of her probation?
Ms. McKay, did you take the courses they wanted you to take?
Yes, I did. All I owe was fines and costs. I did everything I was supposed to do.
Okay. Ms. McKay, is there anything you'd like to say on your own behalf?
No, just that I'm trying. I mean, it's hard, and this is my only option. That's all I have is my job, and I'm trying really hard just to get my life together, you know?
Okay. Ms. McKay, how many people do you have as dependents? Is it just you?
Yeah, it's me and my older sister, but she stay in Indiana now, so I'm out here right now and I'm staying with a friend. I go to work at 4 to 12 every night. I'm the cook. I close there, and I've been working there for 2 weeks now.
All right, sentence the court that I'm going to revoke and terminate your probation on both files. I'm gonna give you credit for time served. You're going to get a copy of your notice of right to appellate review on both of these files, Ms. McKay. They're gonna have you initial and date one copy for each file. The other copies are for you. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, and you'll be released from the jail today, all right, Ms. McKay?
Okay, thank you.
Thank you so
Thank you,
much.
good luck to you.
Thank you, Your Honor.
Thank you. All right, Miss Underwood, what about Miss, oh, well, he said he's on his way, Mr. Barnett, okay. So, let's see who we get from the jail next. Huh?
You're gonna have court again after I get a couple more. I'm gonna get a shader. Crabtree. You're gonna go upstairs in 1 second. So. I love you. Thank you. And then you can come with me, you can go upstairs.
All right, are you Leanne Crabtree?
Yes, I am.
All right, Ms. Crabtree, we are here on a request and warrant for probation violation. This is file number 22-20733FH. This is a Judge Olsaver file. I will be handling it for Judge Olsaver today. So, Ms. Crabtree, in this file, the allegations are that you have violated your probation by committing the following technical violations. And Ms. Underwood, this is from April 15 of 25. So that was quite a few months ago, so I don't think it's technical anymore. So, ma'am, it's alleged that you failed to report to your Jackson County probation agent on or about March 25 of 2025 or any time thereafter, that you failed to contact your Lenawee County probation agent about your whereabouts, and that you failed to submit to a scheduled substance abuse test on or about March 22nd of 2025. While these were technical violations at the time the warrant was issued, it has been well over 90 days, and these are now non-technical violations. So, Ms. Crabtree, you're on probation for, oh, you have a double, okay, let me see. So you pled to possession of analogs with a second subsequent notice. So the maximum penalty would be up to 4 years in prison. Let me double check. It looks like 4 years in prison. This isn't your first violation either. So, Miss Crabtree, you do have a right to have an attorney represent you here today in all subsequent hearings. If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
I have an attorney.
Who's your attorney?
Ron Grimm.
All right, is he coming in today? When's he coming in?
As soon as he's notified, my boyfriend will probably notify him today. I'm
No
sure he
idea what
doesn't
you
know
just
I'm
said,
here.
ma'am. Hold on. Scoot forward a little bit and speak a little bit louder because I wasn't able to hear that.
I don't think he knows I'm in here yet.
So have you retained him?
Yes.
Okay, for this?
Yes.
Okay, all right,
I'm sorry. I just wanted to say, I just got out of Jackson County Jail. I was in Jackson County. I have a double.
So ma'am,
case.
hold on a second, Miss Crabtree, hold on. So you're saying you have counsel, So who is this attorney?
Ron Grimm,
Ron Grimm. All right, and he's out of where?
Lansing.
Lansing. All right, so we can put a call in to see if he's going to appear today on your behalf. So let us do that and we'll see if he's gonna pop in, okay?
Okay, thank you.
All right, so go ahead and tell them I'll see the next person and we'll see you in a few minutes, all right?
Okay. Yes.
Miss Adams, do we have any of those little tiny yellow Post-it notes? I have Judge Olsaver's files and I do things different. No. Do you have some?
I have this back.
No, he likes these little ones. See. All right, Becky will bring me some.
I'm gonna step out and make a phone call regarding this case too.
Okay.
Oh, Sugar Farm.
A lot of running last night.
Did a lot of running.
Yeah.
Please rise for court session.
All right, so I have somebody from the jail. What's your name, please?
Joshua Coleman.
All right, so Mr. Coleman, thank you. This is in the matter of the people of the state of Michigan versus Joshua Glenn Coleman, file number 25-22283FH. So, Mr. Coleman, we are here. There's only one file. All right. Miss Adams, it says the original plea agreement. Oh, there. No. The original plea agreement says both files. Are there two files on this or just the one?
I guess the warrant was only issued on the one. That's the
Okay.
only one they gave us.
Okay, so this is file number 25-22283FH. And Miss Adams, if you can look up file number 25-22320FH. Looks like he pled to a use of methamphetamine on both of these files. So, Mr. Coleman, we're here on a violation of probation. This is a Judge Olsaver file. So I'm handling that for him today. So Mr. Coleman, it is alleged that you have violated the terms of your probation and that you failed to enter and successfully complete inpatient treatment at Dawn Farms. Allegedly, you left treatment against staff advice on July 15 of 2025 and failed to reach out to pretrial services coordinator Darren Coast upon leaving treatment to get set back up with drug testing. So it looks like you entered a plea and you have not been sentenced yet on these files. So this is actually a bond condition, Ms. Underwood. So, Mr. Coleman, who is your attorney on this file?
That would be Mr. Dager Margosian, Your Honor.
All right, so Mr. Dagger Marcosian represents you. No, hold on one second, because I don't want you to say anything that I could hold against you. So Mr. Dagger Marcosian is your attorney on this underlying file. So today you're here on a contempt of court. So a contempt of court could result in up to a 93-day jail term, but also this could result in your bond being raised on the underlying file and perhaps loss of your plea offer under the new laws in the state of Michigan. So the plea offer you had, you entered a plea of use of methamphetamine and were offered 7411 status. Once you violate probation,
Yeah.
I don't know, I got a plea offer. I don't know if you've entered yet, but
I've never I've heard about my plea.
hold on, just stop. So if you violate bond conditions, the court is not responsible for what happens at the time of plea or sentencing. Okay, so Ms. Underwood,
And I was to rehab on my own.
Hold on. So in this, it looks like you're arraigned, your attorney showed up, there was a plea agreement reached, but there was not a signed plea rights agreement. You're at Dawn Farms, they faxed the plea advice of rights to the number given. It looks like the defendant didn't leave or drop out of the Zoom meeting. Darren Coast then contacted Spera Dawn Farms and was advised that you had left the facility against staff advice the day before and was not there. And there was a bench warrant for violation. And it was supposed to be issued on both files, but it only got issued on the one file, Ms. Underwood. So it's only issued on file number 25-22283FH. So, Mr. Coleman, what we're here today on is a 93-day contempt of court. Do you understand that? So if I were to find you guilty or you plead guilty, you could be facing up to 93 days in jail. Do you understand that?
Yes, ma'am.
Okay. Now, you do have a right to have an attorney represent you here today on the contempt of court. If you can't afford to hire one, we can appoint you one at public expense. I'm assuming because you already have a public defender, you're eligible for court-appointed counsel. Would you like to speak with a court-appointed attorney today?
Yeah.
Okay, so Mr. Coleman, I'm going to open up a breakout room and you go ahead and join that and go talk to Ms. Underwood and Mr. Graham. Once I'm done with Mr. Coleman, I'll bring your client back, okay? Mr. Barnett?
Yep.
Okay. All right, Ms. Underwood, let me close the breakout room. Bring your client back.
Your Honor.
Hold on, let me get him back. Let me get him back before we talk. All right.
I
so
wasn't
we're back.
even talking to him.
Hold on a minute. Everybody hold on. So we are back on the record with Mr. Coleman. So Ms. Underwood, how does Mr. Coleman wish to proceed today?
Mr. Coleman wishes to plead not guilty, Your Honor. It was not Mr. Coleman's understanding that rehab was part of his bond. I
went by myself.
Okay, don't say anything else, Mr. Coleman.
I'm sorry.
All right. Mr. Coast, perhaps you can enlighten the court. So I do have a letter dated July 14 that Mr. Coleman is at Dawn Farms. He entered their 30-day program on July 7. And then on July 16, I have the violation of probation. So
correct, Judge. He actually he appeared in court on 7/16. He is claiming he was at Dawn Farms. I did reach out to Dawn Farms, and they said that he actually left the day before. That he left against staff advice. He is part of his bond. He's to do drug screening. As prior to entering treatment, he wasn't showing up, and he was testing positive for ecstasy, meth, THC. And so when he was not in treatment, he was not doing his drug testing. So the last I heard from him was back on 7/16, when he was claiming he was in treatment when in fact he was not.
And that's my negligence. I completely forgot that I had to call you when I left rehab.
okay, so you're pleading not guilty, and now you're telling me you're guilty. So this is why it's really important. This is really important that people not talk once they have an attorney without their attorney's advice. Because anything you say here today, I can use against you, right? So that's why you got to be careful what you say, all right? And that's the only reason I admonish you from speaking. So Ms. Underwood, so Mr. Coast, was it a bond condition that he entered the program?
Judge, it was testing. Let me look at my notes here.
Because I'm seeing that we have a violation of bond conditions back on June 12 for possession of methamphetamine. We have, a bond condition must comply with the requirements made by Darren Coast, which would be drug testing. He must provide a consent to Darren Coast if he enters inpatient treatment, and must report to Darren Coast today or report to inpatient treatment. So he was ordered to report to inpatient treatment as a condition of his bond on June 12th.
And he did enter Dawn Farms, Judge, on 7/7, but then he abruptly left on 7/15 without successfully completing. And then after getting out, he failed to start back up at the colors with the drug testing.
All right, so Ms. Underwood, it does appear that he was ordered to enter the rehab facility, and that he did enter it, and then he failed to, well, he left. So Ms. Underwood, that's the documents I have.
Thank you, Your Honor. I would again ask the court to enter a not guilty plea on his behalf and set this for Mr. Dager-Margosian on Wednesday, Your Honor.
All right, so I'm going to enter not guilty. And then Mr. Dager-Margosian, let's see, next Wednesday will be, let's see, so I'll set it for September 17th or September 17 at 8:15 in the morning. I'll enter a plea of not guilty, and then Mr. Dagmar goes in. I'm sure we'll get a hold of you before that, Mr. Coleman, and then he'll see you on that day. All right?
Okay, I have one more question, Your Honor.
Sure.
You said a probation violation. Am I able to like?
No, I misspoke. It's a bond violation.
Okay.
Yeah, it was a bond.
I was gonna say, can I? Cause I was in the middle of talking to her and it abruptly cut me out.
Say it again.
I said I was in the middle of talking to my lawyer and it abruptly cut me out in the middle of me talking to her. I was trying to explain that to you.
Okay, so, all right, so you're coming back next Wednesday with your attorney, Mr. Dagmar goes in, right?
Okay.
And so he will get a hold of you probably this week and talk to you, or tomorrow, or next week. He's really good about that too. So you'll get a chance to speak with your attorney, all right? All right, your bond's continued. Thank you, Mr. Coleman. All right, Mr. Coleman, you're all set. You can go. I'm gonna call the jail for, this is Judge Anzalone. Let me see, Miss Crabtree's attorney's here, so if I could see her back.
Okay, are you done with, Mr. Coleman?
Yep, yep, I'm done with him.
Okay.
Thank you.
Good.
Bye. I don't know.
Yeah, and then I'm gonna send you upstairs for a shaver.
Hey, Becky. Miss Adams.
Yes, Judge.
My display is doing that thing it does.
Okay, very good.
All right, Miss Underwood, Mr. Barnett is here.
Oh, great. Thank you. I'll be right in.
And I hit back because there's an arrow, but I won't go back. It will figure it out. It's like, or I just have to disconnect and do it again, which I can do. Let me just log off on the silver one and log back on. All right, you're not gonna. Mr. Grimm, did you get the paperwork for Miss Crabtree?
Let me check. I'm not sure. Just a minute, I'll check.
Me? You want to approach me willingly? Sure. Come on. Yeah.
We've discussed it, but
Yeah.
it's not following and go out in the mail.
It's okay. All right, so I've given Miss Underwood a copy of the probation violation report. She'll review that with you. Okay, so we are back on the record in the matter of the people of the state of Michigan versus Leanne Rosanna Crabtree. So Miss Crabtree, we were able to reach Mr. Grimm and he was kind enough to be able to pop in this morning on your behalf. So Mr. Grimm, did you receive a copy? Did they email you the probation violation? Probation warrant violation?
They have, and I'm trying to. They have, and I'm trying to print it right now. There we go.
So I'm going to go ahead and pop you two in a breakout room. And that way you can have a moment to chat about it, okay?
Thank you.
Thank you.
All right, there you go. Go ahead and join that breakout room. Look how organized Judge Olsaver's files are. There. I try not to commit chaos in his files. All right, Mr. Grimm, I will bring your client back.
Thank you.
You're welcome. All right, we are back on the record in the matter of the people of the state of Michigan versus Leanne Crabtree. Mr. Grimm, what is your P number, please?
60953.
Thank you, sir. So this is a Judge Olsaver file. Judge Olsaver is not available today. That's why I'm handling this. Mr. Grimm, just for the record, I do notice that we have multiple contempt of courts in violation of probation, failure to report. There was another one, leaving treatment without permission, failing to report, contempt of court for failure to appear for violation of probation summons. And then this allegation, she failed to report to the Jackson County probation agent and failed to contact the Lenawee County Probation Department and failed to submit to a scheduled substance abuse test on March 22nd. So, Ms. Crabtree, you would ask for your attorney, and as I said, he very kindly was available this morning to you. Are you satisfied with Mr. Grimm as your attorney and the advice that he has given you?
Yes, ma'am.
Okay, excellent. Mr. Grimm, how would you like to proceed today?
Well, Your Honor, I think this is, I know she failed to report to Lenawee County, and on the Jackson County failing to report, they arrested her earlier this year on a probation violation, and they then sentenced her to, I believe it was 185 or 270 days, I believe, in Jackson County Jail. She just got out a couple of weeks ago, and I think it was at the end of July. And I made a phone call to Lenawee County to Ms. Teskey and was told that she was out indefinitely. And I left a message then for somebody to call me back. We've been playing telephone tag apparently. And I believe this is all part of this has been because she was incarcerated in Jackson County. And frankly, I'd like to see it dismissed, but for today's purposes, I would just plead no contest and send it as soon as possible for a pretrial.
Okay, and Mr. Grimm, when was she sentenced to jail like when did she go into custody in Jackson?
You know, I don't have her file in front of me. I'm not in the office right now. Okay,
So Ms.
July 1st.
Crabtree, okay, you went to jail July 1 in Jackson County, and when did you get out?
In September. I'm not sure.
Okay.
It is September. I think it was.
It's September, so was it yesterday, the day before, last week?
No, I'm sorry, like September 5th.
Okay. All right.
Your
Okay.
Honor, if you give me just a second, I can get the exact dates.
Thank you.
Okay. All right. And Mr. Grimm, this is Ms. Teskey. She is back.
Great, thank you.
Thank you, Ms. Underwood. I'll be with you in just a minute.
Give me just a couple minutes, Judge, and I'll have it. He had a warrant.
Wait, August. It was August, sorry. I mean,
Judge, it appears that she was arrested on 7/1 of 2025. On 8/5 of 2025, she pled guilty, probation revoked, 270 days jail with 185 days credit. I do not have a release date from jail in the computer.
Oh, it's only the 12th of September, so it had to be in the last 2 weeks. So, all right. So Mr. Grimm, then, we have the failure to report back in March and substance abuse test back in March. And that's through Jackson County yet. So, Mr. Grimm, how did you want to proceed today?
We'll plead not guilty and ask for a new date to be set shortly.
Okay, so I will enter a plea of not guilty. This is a Judge Olsaver file. Mr. Grimm, are you available September 17 at 8:15 in the morning?
I am not. I have to be in Eaton County at 8:30 and it'll probably take me most of the morning.
No, how about September 24 at 8:15?
Yes, I can make that one work.
All right, I will set this over to September 24 at 8:15 in the morning in front of Judge Olsaver. And I'll enter a plea of not guilty, and for bonds I'll set bond in the amount of 25,000 cash assured. Okay.
Thank you, Your Honor.
All right, Ms. Crabtree, good luck, and you'll be in front of Judge Olsaver next time, Mr. Grimm.
Thank you, Your Honor.
Leanne.
Yes.
If you get out of jail at any point, you post bond, you need to come see me immediately.
Okay.
Okay?
All right.
Thank you.
Thank you.
And Mr. Grimm, you can appear via Zoom. You'll get a notice of hearing, all right?
Thank you very much, Your Honor. Have a good day.
You too, thank you.
Thank you.
All right, Miss Underwood, we are back to you. So this is Mr. Barnett. Come on.
Ready on Mr. Barnett.
Yes. So this is in the matter of the people of the state of Michigan versus Kevin Lee Barnett, file number 25-22302FH. You guys stand at the podium, please. This is a date and time set for violation of probation sentencing. Mr. Barnett, it was set for 8 a.m. Miss Holly did advise that you reported as required on Tuesday. Miss Underwood advised that she spoke to you. So remember though, 8 o'clock is 8 o'clock, right? Okay. So Miss Underwood, have you had ample time to speak with Mr. Barnett and review the
We have,
probation violation report?
Judge, I do have a correction. The violation report says this is a technical violation, but the original warrant is correct to non-technical because it's a violation of specific no contact with person.
Okay.
Just, that's it.
Okay. Do you understand that?
I do. We pled guilty to a technical violation, but if Ms. Holly says it's not technical now, I find that interesting.
It's legislation.
It's what?
It's on the legislation paperwork that we got about the whole technical, non-technical.
So they keep changing the rules at the legislative
It's
level.
always been, I just didn't notice it.
Okay. Well, I'm not going to let that impact what I do here today, Ms. Underwood.
Thank you.
Okay. All right. So, Mr. Barnett, you've reviewed the probation violation report.
Yes.
You've had ample time to discuss that with Ms. Underwood.
I have.
You are satisfied with Ms. Underwood as your attorney and the advice that she has given you? Right, you
Sir,
gotta
please
speak up a
speak
little
up.
bit.
I am.
Okay, we record this so that if people appeal it, we can get the recording. All right, so Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information?
We don't, Your Honor.
Okay, now, Ms. Underwood, you did provide to the court a letter from Bethany Harps Teague asking that she wants the no contact removed. The notes, though, do require and acknowledge that he has to complete certain programming before the court will do that. Okay.
Thank you, Your Honor.
All right, so I do appreciate the letter, and I'm gonna, if it's all right, I'll give that to Miss Holly. Is that all right, Mr. Barnett?
Well, it's not,
I didn't put it in the file.
It'll go in the file, so we have,
She was offered one, Your Honor, she declined it.
I can't hear you.
She was offered one, she declined it.
Okay, but I'm gonna ask that it,
for both of us.
Yes.
Your Honor.
yeah, but I'm gonna have it put in the file as part of the file. So we have that when they complete all their programming, and then we can review lifting the no contact, okay?
Thank you.
Okay, so before the court passes sentence, is there anything you'd like to say on behalf of Mr. Barnett?
Absolutely, Your Honor. Number one, Mr. Barnett, stand here, Your Honor. This is I believe, resisting obstruction case. That was placed on Mr. Barnett as part, because there was a misdemeanor domestic violence case started downstairs or charged downstairs. That case was dismissed. Mr. Barnett, Your Honor, works at Aubrey's. He has a regular job. Mr. Barnett, as you can see from the letter, has addressed many issues that he has. He attends AA and church. Both he and Ms. Teague have went to counseling. He understands that that there is a no contact order, Your Honor. And he shouldn't have violated that. But I do think Mr. Barnett has a number of positives that we can look at, even though this violation came up. I would ask the court, I know the recommendation is 15 days in jail with credit for, I believe, 2 that he served. I would ask the court to consider suspending that, allowing Mr. Barnett to go back to work so he doesn't lose his job. And allowing Mr. Barnett to properly, Ms. Herbst to properly notice the court that she wishes this lifted, Your Honor. And I would hope the court would see fit to give some mercy in this matter, Your Honor.
Mr. Barnett, is there anything you'd like to say on your own behalf?
Yes, Your Honor, first and foremost, I would like to thank you.
You got to speak up for us just a little bit. I'm sorry, the audio is not the greatest in the courtroom.
I said, first and foremost, I would like to thank you for granting me the PR bond. I do appreciate that. I didn't explain anything that was going on. We had a funeral last Saturday, go to my aunt's. I apologize for my disruptive and disrespectful outbursts on the Zoom as well. That day that we had the agreement. I do still hold a job. I am going to college. I actually am going to college, so I have that going for me. I would like to continue those courses. I would like to continue my education and hold down a job. My extensive criminal history, it is actually very difficult to get a job. I recently applied to 2 other jobs that have declined me solely on my criminal history. So if there's any way that I could possibly even get, you still recommend jail time, I'd like to do maybe like in the middle of the week or weekends if that's suffices for you. I would oblige. I completely agree with that. I also did write a email to a Michael, the head of Department of Probation. I couldn't find either one.
Michael Stevenson?
Yes. I couldn't find an email for you or Holly.
Yeah, you're not, hopefully never find my email, but I don't know about Miss Holly, so.
Given Mr. Stevens a promotion.
I can't hear you, Rhonda.
I said we gave Mr. Stevenson a promotion.
Yeah, you got a promotion. Go ahead.
Also, there was no actual domestic violence charges at all. I just want to clarify that. This charge, prior charge, any ones that was dismissed, there was no domestic violence. But the programs that I need to proceed in order to get the no contact order on is still, I got the information for the PayPal, the contact, the individual on those programs. And like I said at the time, the my job has postponed my my work hours because of the course until after everything has been taken care of. So if there's any way I can possibly evade jail time, or not evade it, I guess that's coming away from it. But not do any jail time, so I can still have my job and still be able to proceed with my education. Be more than happy to do anything else that I could possibly do, and I didn't need to do late, that it might be helping continue forward.
Anything else? So you've taken a domestic violence program before. When did you take that? Before your kids were born. So when you say, why do I have to take another one? It's because you took one years ago?
Well, I said take one at all.
Okay. So here's the thing. As a former defense attorney, I can tell you, you were originally charged with assault with a dangerous weapon and allegedly made an assault upon the protected party, in this case with a motor vehicle. So you weren't charged with domestic, but you were initially charged with an assaultive offense against a woman. Okay, do you understand that? A good defense attorney means that maybe you didn't get convicted of it and you pled to something else. Doesn't mean it didn't happen. Doesn't mean it did, that you were charged with it, but you were charged with it. Hence the reason you're required to take a domestic violence class, okay? So, you know, obviously your defense attorney did a good job because you ended up pleading to, I think, an Arno and a careless driving. So, but you were initially charged with it, which is why there's a no contact and which is why there is requirement for domestic violence programming. So, just because you didn't get convicted doesn't mean it did or did not happen. So I am going to continue your probation. Ms. Holly is fairly easy to deal with. You do what she says to do. You complete all your programming, you pay your fines and costs, and you'll have zero issues. But arguing with her about whether you need to take domestic violence programming or whatever isn't going to help because it was ordered by the court, right? So she doesn't have a right to lift that. I am going to, now listen to me, I'm going to order that you complete this domestic violence counseling and you have no contact with Bethany Harpsey until you complete that. Once you complete all that, you can move to have that lifted. But until you complete it, you can't. It's the same in any bond condition. You got to complete the programming before you can have contact. If you continue to have contact with her, you're going to go to jail. You're going to sit in jail. You got it?
Understood.
All right. Obviously, it's important that you're employed. Make sure you're making your monthly payments on your fines and costs to get those paid down. It is your first violation. I'm going to give you credit for the 2 days you've already served, but know that if you come back again on this, it will be a non-technical violation and you could be facing more than 15 days in jail.
Understood.
Do you have any questions?
No.
Okay. So my bailiff's going to hand down to you your notice of right to appellate review.
We ask him where he lives right now.
No, because we're on YouTube. But I'm going to give him a post.
I just know that I'm still getting.
Hold on. I'm going to give him a post-it note
All right.
to write it down for you. Here. Oh, well, my bailiff already has one because he's always way ahead of me. So if you could please write your address down. I don't want to hear that you're at her house.
Sure.
Okay, so write your address down so we can give that to Miss Holly.
I don't need their.
All right, so Mr. Barnett has signed the notice of right to appellate review. Obviously, if you wish to appeal this sentence, you would fill out the information on the form, and mail it to the address listed on the form within 42 days. Instructions, Ms. Holly, from Mr. Barnett.
Yes, he needs a report as directed.
Tuesday.
And I don't want to give any more information to anybody that you're still over there. I don't care what she said.
If you got stuff there, you have someone else go get your stuff, okay? Don't, and get this class done, and then we'll review it again. All right, thank you.
Thank you. Thank you,
Thank you, Ms. Underwood.
have a good weekend, everyone.
You too. Thank you. So, Mr. Sanchez, is Katerina Garza here? Is Mr. Mott your attorney today?
No, I don't have an attorney.
Okay. All right. So, in the matter of Katerina Garza, you'll have a seat here versus Anthony Sanchez. You'll have a seat over there, sir. This is file number 2010-355.